All right, welcome back to Justice for Y'all. I'm Paul Painter, and with me is Andrew Bowen and Stephen Morrison. Gents, how are you?
Hey, Paul.
Paul, how you doing?
I'm doing good. Doing good. Just proud to be here.
Proud to be here. Glad to be here. Oh, the sun came out.
All right.
Sun
That
came
was kind
out.
of nasty
Yeah,
a minute ago.
it was.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the Southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
Well, what are we going to talk about today, guys?
Well, we're got a series to continue here.
We are, yeah. So we talked about voir dire in our last episode, and now we're going to move on to the next phase of trial, which is opening statements. So we've picked the jury, which we learned last time is not actually what we do, but we picked the jury, and they have been sworn in, and now the judge says we're ready for opening statements, and the plaintiff goes first, as we've talked about before, always goes first of the two. What is an opening statement?
Well, Paul, what happens if there's a counterclaim? Who goes first?
It would still be the first to file, wouldn't it?
I would think so.
Yeah.
I think that's how that
Still
works.
the plaintiff.
We didn't practice
Put him
that.
in the spot.
But that's mine. I believe that's correct. Now, I think the parties can always discuss, or the judge, is in a situation like that. There may be an arrangement.
Sometimes the judge will switch the parties, make
Right.
the defendant the plaintiff and the plaintiff defendant. Not really in our cases, but that
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 does
can
happen.
happen
Yep.
with some like contractual
Yep.
type
Like a
cases.
declaration or declaratory action. A deck action.
Easy for you to say.
Clearly. All right, so opening
Anyway,
statements.
so opening statements. Andrew, what's an
Well-
opening statement?
Well, one thing it is not is it is not argument.
It is not argument.
Even though it is absolutely argument.
So, well, you have to be creative to figure out ways
persuasive.
to argue your case and be persuasive in the opening statement, which is supposed to be an outline for the jury of what your case is going to consist of.
Mm-hmm.
So the classic opening statement will be, ladies and gentlemen of the jury, we are going to show you, or the evidence is going to show what happened in this case. And, you're going to hear from this witness who's going to tell you X, Y, and Z, and you're going to see photographs of the wreck scene. And by the end of it, you're going to be so convinced that we're right that you're going to return a verdict for us. Thank you. And you sit down.
That's it. Thanks for listening.
I like to think of in the movie A Few Good Men, Kevin Bacon's opening statement is actually a very good, concise opening statement when he talks about the facts and what happens, and it says the same facts you're going to hear from them, and they're going to try to say it doesn't mean anything, but this is what happened, and it's effective opening statement.
So what are some of the things that you think about when you're structuring it? If you're doing the opening statement, but you're also aware that you're going to do a closing statement, you're going to have witnesses coming. What kind of things do you do? Do you take notes, and how do you refer to those? How do you incorporate that later on when you're doing your closing statement? We'll talk about that in another session. But
Well, the one thing that the opening statement has that is unique in your trial preparation, it is the one thing that you can control and plan exactly what you're going to say ahead of time. Voir dire is conversational. Witnesses, even your own witnesses, you got to rely on somebody else. So while you can plan the script, you can't know exactly how it's going to go. Opening statement, you can sit there in front of the mirror if you want to and practice exactly what you're going to say. So what you want to do is, of course, tell your client's version of the story. You want to tell the jury what the evidence they need to look for is, how we're going to present this evidence, and kind of preview what the other side is going to do while undermining what they're going to do.
Yeah.
And that's
if
kind
they're-
of the short version of it.
And anything you tell the jury that they're going to see and hear, anything you say you're going to do, you better make sure you're going to be able to do.
well, that's
100%.
you
Is
got
that what you're getting at?
Well, I mean, a little bit, yeah. It's because your credibility is going to be tested because it's the first. I mean, you've done voir dire, so you've talked to them before, but this is you. You are making promises
Yeah.
to them,
Right.
and building your credibility here, and they really will be testing everything against that. And you will be testing. Your opponent will be testing you. when it comes time and the evidence has been submitted, if the evidence didn't show what you said it, or what you say it is one way to interpret it, and it didn't really pan out like that, and you didn't do a good job or your witnesses fell apart, whatever happened, it really is going to hurt you on the back end. You need to be aware of that. And the other piece of it is taking notes when your opponent's doing their opening. What are they promising to the jury?
Right.
What are some things that you can write down that you can come back to and ask?
In
Did they
closing
actually do it?
argument, you say, now, Mr. Lawyer told you that he was going to show you this, that, and the other. You didn't hear anything about that, did you?
Yeah.
They're just telling you stories.
Right. They've been hiding the ball and misleading you from the very beginning of this case.
That's right.
So
One other thing that you need to be aware of and use opening statements for is to go ahead and address any bad facts in your case. You don't. If there's a bad fact, you want the jury to hear it from you first, not from the defendants.
Why is that, Andrew?
Well, again, it goes to credibility, and it also goes from to if you present it first, you get to frame it.
Yeah. You can neutralize it or mitigate at least.
Yeah. And then similarly to what you were talking about is making sure that what you do in opening will appear in evidence and will be there at closing for you to talk about. I mean, that's part of establishing an overall theme for the case that you want to weave. There are facts and issues you want to weave throughout the entire case.
and that was what I was getting ready to say, is this is the chance to start framing your case. I think that you said that perfectly. And establish that theme that you're going to use all the way through the case, and you should have this idea of this is what the case is about. Because at the end of the day, you can take very complicated cases, and you need to be able to explain it to folks in a simple one-sentence way. And that's just good communication. So you make it what this case is about. And it can be about, one of the best ones I heard was lawyer who's a great lawyer named Bill Stone had this case and had a man who I think died in a tractor trailer wreck, and he tried this case. The man had done very well, but was really close with had close friends, close with his family, and was a very religious man, and said this case is about friends, faith, and family. And throughout the trial, he kept going back to it, and even to the point where asking some of the defense witnesses, what's important in life, and friends, faith, and family. And so the damages, which this was a damages case, there was no liability issue, were all about that friends, faith, and family. So when you talk about those things, you started an opening statement. And what we often do is we start in the very first sentence of what we tell the jury. This is a case about friends, faith, and family. And then you keep talking about it and make sure that it's woven in there at all phases. Now, it has to actually relate to your case. But,
right.
Just putting out there, if you don't create the theme, then it leaves room for 12 different people on the jury to come up with their own framing of how they see it. Now, they may do that anyway, but if you frame it, especially an opening statement, then that can be the lens by which the jury sees the evidence throughout the case. And that's a huge advantage for the plaintiff to get to go first, because when you tell the story of what happened, if the jury can see it in their mind's eye, and we've done some training on that of using, the way you kind of gesticulate and use your hands to make sure the jury can imagine what's going on. Once somebody sees something in their mind's eye, it's hard to change that, even if it's wrong.
Yeah.
Even if the evidence sort of shows it's wrong. So once you see it one way, people get locked in on that. So that's an important part of your storytelling. So you have theme, and then your storytelling of it. And some of the ways with storytelling we do is, this case about friends, faith, and family. This case concerns a tractor trailer wreck where a drunk driver, ran into a family of four and on I-16. And then we go into telling the actual story. So you have your theme, you have your expanded theme, and the story you tell, we always do it in present sense. So we say, it's January 5th, 2002. Mr. Smith is driving down the road. Instead of saying it was, this date, you do it is. And so as you are telling the story, the people in the courtroom are living it with you. And again, that gives that framework to where they see in their mind's eye.
What are some of the themes you have used or ways that you've developed themes in the cases you've done? Is there a magic to it?
There is not a magic to it. The one rule is it has to be simple. You can't, you start getting anything more than a sentence and it's too long. It usually will come to you when you live with the case, and suddenly it'll just make sense.
Yeah.
You've got to feel the theme. The theme is all about feel. It's not about that. Then you're not talking about the facts and that kind of stuff. It's just like, what does this feel like? From what angle are we seeing this? And if you're seeing it from the perspective, the case we just tried, you came up with the theme. There was years and years and years. We actually had two themes, and we saved one, which is not commonly done. We didn't, because we wanted to sort of surprise them. One of them was the two Savannahs, and the other one was years and years and years, because this case was 10 years old. It was all the years which the client had suffered and the years in which the defective curb had been there.
We just about given up on it.
We had
just a nice theme at that by the time we got to that one.
Yeah.
It was like this. We tried a few things, and it was just like didn't have the feel.
Well, and that's the other thing. You can't force it.
You can't,
sometimes a case just is straightforward case.
Yeah.
And
it's about a person that got hurt.
Yeah. And that may be a case that you don't end up trying, but if you find yourself trying that case, you can't force a square peg into a round hole.
No.
The jury will feel that too.
Yeah. It's got to be real. Yeah, it's definitely, and you have to believe in your theme to be able to say it. So that's important. So once we tell the story of what happened, the way we typically do it, and we don't do it cookie cutter, but we'll sort of stop whenever the event happens. We'll do the lead up of what happens, and if you can do it, if there's more to the story, if it's this tractor trailer wreck, and then you say, when we found out the company, didn't do a background search on this guy and he's got 8 DUIs or something like that, or they have purposely, were falsifying records to let him drive more hours, or whatever it is.
Cook the books on his medical test or something.
Yeah. One thing that's good to do in that kind of storytelling, I think, is the old, like Paul Harvey, the rest of the story, for those old enough to remember Paul Harvey.
You meant to read me in on that one.
I know Andrew remembers him.
And that's the rest of the story.
He would always tell, it was on the radio, and they'd be 5 minutes long, something like that, and he'd go in and tell a story, and then he would say sort of the punchline for what it was, and at the end he'd say, and now you know the rest of the story. But if you can do that, if you can kind of sort of lay out the basic facts and then throw in, here's what really happened, it makes for powerful storytelling. But you want to get that story told the right way in opening statement.
Right. It's supposed to be a bare recitation of what the facts are going to be, but you do make it into storytelling, and
it's still what the facts are going to be. You're just telling it in story form.
Right.
That's right.
Talk about objections during opening statement.
I found objections in opening statement are rare. You can get into them if you're blatantly arguing.
Yeah.
If you get up there and say, this defendant is just full of it and he's lying left and right and that kind of stuff, that's going to draw objection for being argumentative. But you can say, you will see that the defendant has testified that she's going to testify that she did not run the red light. However, you also hear that she pled guilty to the fine for playing the red light, which you can,
and you'll be the judge of her credibility on that.
Yeah.
Right.
Yeah. You've got the jury is the one who decides.
So you just got to be more nuanced
Yeah.
about how you say it.
And then we're pretty light on the law in the opening.
Almost no law in the opening, because it is about the evidence. And so it's typically not really proper to talk about the law at that phase. If you
may reference the judge is going to instruct you on the law.
Oh yeah, that's fine.
But
yeah, you can tell them, at the end of the case, the judge is going to tell you the law that you will apply to these facts, that come into evidence. Right. I'll tell you another objection that you do see sometimes is, and I had this happen in a case where during opening I threw up a picture of the scene of the wreck. And the objection was, well, Your Honor, that's not in evidence. He shouldn't be showing it to the jury. And basically we went to the bench, and the judge said, well, haven't y'all agreed that this is going to be in evidence? You know, and is there any objection to it when it is tendered? And there wasn't. So she was, in that case, said, well, it's going to be in evidence. I'll let you use it. But if there's something that is the admissibility of which is contested,
Yeah.
You very well may draw an objection, and it may be a valid objection that you can't show that picture or show that exhibit because it's not yet in evidence, and it may not be in evidence.
And you need to be prepared for that because the law in Georgia, at least, is you show the jury the evidence you think is going to get in. But there are some things, if you're really worried about whether a piece of evidence is going to get in or out or not, and you want to do an opening statement, you should file a motion in limine, which is a pretrial motion on evidentiary issues, to ensure that it's going to get in.
Yeah.
Because if it's one of those
Front load that issue.
Yeah, some of these you can't put the toothpaste back in the tube, so it's careful. And how that you handle that, if the other side's doing it, is interesting too. So this wasn't our trial, but a friend of ours tried a case, and it was that slip and fall in a bathtub case, and the plaintiff lawyer, a very good lawyer, was putting up the presentation, and there was a PowerPoint that talked about all the complaints that had been there about this hotel and having bathtubs that were overly slippery, and put up some. They weren't the actual complaints, but it was sort of a calendar, I think, with the complaints on it, something like that, and said, "Oh, you're going to hear about these complaints." Well, the defense lawyer, instead of just sitting there and either going up to the bench for a sidebar or, just letting it happen, and then, it doesn't get into evidence. Like they said you're going to say their complaints. You didn't say anything about that. When stood up, objected in front of the jury, and said, "We don't know if these complaints are going to get into evidence or not." At which point, they didn't end up getting into evidence too.
But they still know they're.
But he validated
But he
them.
validated that they're there. So it was like knowing how to handle that, and that's one of the things, I guess, an overall theme of trial is you're always kind of on display and on show, and you got to think your audience is, at the end of the day, you got three audiences. The main one is the jury, the trial judge is one, and the appellate courts are the third. And so if you're not talking to one of those three entities
And thinking about how all of them are.
yeah, which one's the one you really need to talk to in that particular situation? Because sometimes objecting to something is, even if it's objectionable, is not the right thing to do.
Yep.
But anyway, that's kind
You
of
win the battle and lose the war.
Right.
side. Yeah. Any other objections that you see, Matt?
Well,
Argumentative. If something's not in evidence, if there's something you're saying that violates a motion in limine,
yeah.
Right.
not many other objections there. No.
The one, and this is related to what we've talked about, but the use of demonstratives, which are not, and this is a little fresh off of one of these little tiffs involving this, but a demonstrative is sort of it's not evidence itself. It's not something that's going to go back with the jury, but it's something you show the jury to help them understand the evidence, like a summation of medical bills or medical visual.
Medical illustration.
Yeah, medical illustrations. I mean, it could be if you have, like, we've got a spine. If we took the spine out and we're demonstrating,
Right.
like this is where the area of injury is, that is a demonstrative thing. You're demonstrating.
Yeah.
And it could be you drawing on a whiteboard, like this is the intersection and the car came
Yeah.
here and the other car came here. But the more detailed the demonstrative, like a medical illustration, the more carefully you want to make sure that you can use it, because it does have to be supported by the evidence. And, having it authentic is something that the courts will worry about. So if it's a medical illustration, your best case scenario is to get the doctor, who probably has already testified, like by video, because they don't come to trial typically, to authenticate it and say, yes, this is an accurate depiction of the surgery I did, or whatever.
Right.
Yeah.
Yeah, it fairly accurately depicts we had that come up, and the visual we wanted to use didn't make it into the opening statement, and some of that comes down to the lawyer that you're dealing with and whether or not you're able to work that out. Sometimes lawyers won't push back, but one got pushed back, and we were able to eventually get it in closing, but we had it authenticated by a doctor. And normally you ought to be able to just use something like that in opening statement, but just got to watch out sometimes.
Yeah, and the judge has discretion of what
Yeah.
gets in and out when it comes to those things. The judge has broad discretion, so you got to know your judge. Are they going to let you just put up anything at opening?
Right.
And or are they going to be more of a gatekeeper on those things? So,
And the jury is awesome. You're talking about the audience is not a good time to do a lot of objecting. One, because you might draw the same thing for yourself, but also the jury doesn't. You don't want to start off right out the gate just objecting, causing commotions and things like that. I mean,
Right.
It may backfire on you.
that's right. And we obviously try to put together opening statements that are not subject to objection.
Sure.
I don't recall having drawn an argumentative, objection in a trial, but we certainly are doing our best to argue within the rules.
Yeah.
Anyway, then you talk about the other thing to talk about is the witnesses, and so how are we going to show that, Jane Doe, our client, was injured? Well, first going to hear from her treating, neurosurgeon, doctor whatever, and she's going to tell you X, Y, and Z, and then
Yeah.
we're going to hear from Doctor So and So, and so you kind of want to lay out that evidence, and a way to do it, it's however you can best tell your story and preview the evidence for the jury. What you're really trying to do is get them to, when you hear from this doctor, listen to these 2 points, because
Yeah.
otherwise you're going to hear an hour worth of boring testimony, but listen to these words, and so you're really just trying to prime the jury to hear the things that you need them to hear from the evidence.
And then when they do hear that, they perk up a little bit.
Right, because it's already. Oh yeah, that he told me to look out for that.
Yeah.
So I'm listening now.
So sometimes you even want to use the same words the doctor uses, and you put them up on on the PowerPoint or whatever. Of listen for this. You're gonna tell them the witnesses you expect to hear from. You don't have to go in great detail. At least it depends on the case, of course, but
Bless you.
I think that's the important part. And then we like to preview the defense's case and go ahead and we usually like to take 2 to 3 points that are their main points.
Yeah. So what is the
And
defense
undermine
going to say about all this?
Right. Yeah. What is the defense going to say about all this?
And then you say, well, the defense is going to try to tell you she wasn't hurt, but they're going to have, this hired doctor who's, professional testifying expert that they're paying $1 million to be
Never
in here.
actually treated this patient. Never put his hands on her.
Yeah. And you're going to have to decide whether this person is actually credible to give this opinion or whether they're hired to be here. So
Or whether you trust the doctors that actually treated this person.
And so when you say that, it's like, this is a hired gun, but you can't say this is a hired
Right.
gun. You're going to say, you have to decide whether this person is, just being paid because this is what they're being paid, saying this is being paid to do, or whether they're credible. So you frame what you need the jury to listen to for that witness.
Yeah, not just your evidence, but also you're trying to create their impression of the defense's case now that you get to be the first one to frame it.
And
So,
when you get up there and cross,
powerful
the first thing you
opportunity.
do is, you say, well, how much are you getting paid for this?
Yep.
And then that's what the jury goes back and says, oh, this guy's just getting paid. That's what you hope.
Yeah.
Right.
How do you end it?
How do you end the opening statement?
No, this podcast. No, I'm just kidding. how do you end the opening statement? Yeah. What do you like? I mean, this is very fine for my client.
You don't end it with what the defense is going to say. You do that
Right.
towards the end, but you don't want that to be the last word.
Right.
We always sort of do something like, sort of take a pause and say, ladies and gentlemen, at the end of this case, you are going to see without a doubt that, whatever.
Yeah.
More likely than not.
Yeah. Well,
Well,
our burden of proof is more likely than not, but if it were beyond a reasonable doubt, we'd still prove our case.
Yeah.
And y'all are going to see all this evidence, and we're going to come back after the evidence comes in, have another chance to talk to you, and we're going to ask you to render a verdict for our client.
Sit down.
Yeah.
Now-
Or that's also a good time to leave off something like, and when I ask you to render a verdict that fully
Yeah.
reflects the loss of the faith, family, and friends that Mr. Jones
Yeah.
lost. Whatever.
Yeah. Compensates him for the years and years and years of.
Exactly.
So, I've always said if you're going to criticize somebody, you need to walk them out on their shoes first. That way, when you're done criticizing them, you're a mile away and you got their shoes.
Sage words on that one. Take that one to the bank.
All right, guys. I enjoyed it.
Yeah, it was a
Yeah.
good one.
Bye.
Good stuff. All right. Well,
out.
that's everything, and we'll see you next time on Justice for Y'all. Bye.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.